India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first political legal independent weekly focusing on controversial issues of national and international importance. The video readouts we present to you are regularly the editorial team's choice of the most significant stories we believe should receive close scrutiny and wide circulation. You can watch them along with the visuals or listen to them as you would a podcast. In this week's readout, we focus on the sensitive and controversial issue of the impeachment and removal of sitting judges at any level of the judicial hierarchy. In the most ideal of circumstances, judges are supposed to be above reproach, like Caesar's wife, cleaner than a hound's tooth. But they are not above the law. They are human, they are fallible, they are subject to temptation and allurement and even intimidation. And when they succumb, they must be subjected to the rigors and processes of accountability and even punishment. In India, the comeuppance is through the process of impeachment for those at the top of the pyramid. The so-called lower order is often disciplined through strictures and transfers and inquiries ordered by the higher echelons. In India, no Supreme Court judge has actually been impeached and removed from office. But that does not mean that judges have not faced public charges of wrongdoing and the threat of impeachment. Some of these cases have received wide publicity. Let me enumerate some of them. They include Soumitra Sen. Justice Soumitra Sen of the Calcutta High Court in 2011 avoided the ignominy of becoming the first judge to be impeached by Parliament by tendering his resignation. So he escaped the ultimate punishment. But that was tantamount to impeachment, even though technically he was not impeached. Now, he did this after Raj Sabha had passed the motion making him the first judge to have been impeached by the upper house for misconduct. P.D. Dinakaran. Justice P.D. Dinakaran, Chief Justice of the Sikkim High Court, against whom the Raj Sabha chairman had set up a judicial panel to look into allegations of corruption, resigned in July 2011, again before impeachment proceedings could be initiated against him. Then J.B. Pardiwala. In 2015, a group of 58 Raj Sabha MPs moved an impeachment notice against Justice J.P. Pardiwala of the Gujarat High Court for his, quote, objectionable remarks on the issue of reservations. Hours after the impeachment notice was sent to Hamid Ansari, the judge removed the wording from his judgment and escaped impeachment. Then V. Ramaswamy. Justice V. Ramaswamy has the dubious distinction of being the first judge against whom impeachment proceedings were initiated in 1993. The motion was brought up in the Lok Sabha, but it failed to secure the required two-thirds majority. Justice Ramaswamy was caught in a controversy for spending extravagantly on his official residence during his tenure as Chief Justice of Punjab and Haryana during 1990. Well, this is the way, judges are judged by other people. They are judged harshly. The Supreme Court Bar Association even passed a resolution calling for his impeachment. Now, of course, the most memorable and relatively recent impeachment threat was leveled against no less a person than a serving Chief Justice of India, Deepak Mishra. That happened relatively recently. On 20th April 2018, 7 opposition parties submitted a petition seeking impeachment of Mishra to Vice President Venkaiah Naidu, with signatures from 71 parliamentarians. This was on 23rd April 2018, and the petition was rejected by Venkaiah Naidu primarily on the basis that the complaints were about the internal administration and not misbehavior, and that impeachment would seriously interfere with the constitutionally protected independence of the judiciary. Now, whatever the merits of these cases, the point remains that judges are and must remain vulnerable to critical scrutiny, especially when responsible allegations of misbehavior and corruption are involved. This brings me to the most recent controversy as analyzed for India Legal magazine by our senior editor Sanjay Raman Sinha. Sinha refers to a recent case of a judge helping an accused in a scam. Now, this has led to a debate on whether an internal mode or model of conduct is needed for judges. The controversy stems from a recent statement of the Enforcement Directorate in the Supreme Court, Enforcement Directorate, now popularly known as ED, which has become ubiquitous in investigating different people from different political parties. Well, the same ED in the Supreme Court has made charges implicating a Chhattisgarh High Court judge in helping an accused in the multi-crore public distribution scam. Now, this is a shocker by any stretch of the imagination. Solicitor General Tushar Mehta told the court that WhatsApp chats revealed connivance between accused IAS officers and those holding constitutional posts. Again, whether or not these charges withstand the rigorous scrutiny, and the most rigorous of all scrutinies, there is no gainsaying that the law demands judicial accountability. The impeachment process is quite complex, and many argue that this is rightly so to maintain the independence of the judiciary. The procedure for removal of judges is contained in Article 124 brackets 4 of the Constitution, which says that a judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address supported by not less than 2/3 of the members present and voting. And after this has been presented to the President by both houses of Parliament in the same session. In K. Veeraswamy versus the Union of India and others, 1991, the Supreme Court ruled that in case of an allegation of corruption against a judge of the Supreme Court, the President would order an investigation in consultation with the Chief Justice of India. Now, if the allegation is against the CJI himself, the President would consult other judges and act on their advice. Such removal can be initiated on the ground of proved misbehavior or incapacity. However, the Constitution does not define misbehavior or even incapacity, does not define these two loaded terms. The Law Commission in its 195th report has extensively dealt with the subject with reference to the proposed draft of Judges' Inquiry, the Judges' Inquiry Bill, the draft of this, and this was, I think, in 2006, which sought to establish a National Judicial Council to inquire into allegations of incapacity or misbehavior of judges of the Supreme Court and High Courts. Further, the Judicial Standards and Accountability Bill 2010 tried to lay down enforceable standards of conduct for judges. It proposed to widen the definition of misbehavior by adding corruption or the lack of integrity, which includes delivering judgments for collateral or extraneous reasons, making demands for consideration in cash or kind, or any other action which has the effect of subverting the administration of justice. Presenting the draft bill of 2005, the Law Commission had proposed that complaint procedures be introduced in addition to the earlier reference procedure. In a complaint procedure, a complaint can be made by any person to the Judicial Council against judges of the Supreme Court except the CJI, that is the Chief Justice of India, and Chief Justices and judges of the High Courts. In the reference procedure, if there is a motion by MPs in either house, the Speaker or Chairman can make a reference to the Judicial Council for inquiry not only against the judges but also against the CJI, the Chief Justice of India. However, there is provision for preliminary scrutiny and verification. Minor measures, as they are called, quote unquote, minor measures, were also advocated in the report of 2001 by the National Commission for the Review of the Constitution, headed by no other personage than the former Chief Justice of India, the iconic M.N. Venkatachalaya. The Law Commission held that an investigation by the Judicial Council by way of complaint procedure, in addition to a reference procedure, is not an infringement on the parliamentary process contained in Article 124 brackets 4. Now, going by the cases of judges' missteps, a code of conduct for judges is desirable. Most of the judiciaries in several countries have such codes. A breach of the code of conduct can be treated as misbehavior. Then, depending on the severity of misbehavior, minor measures could be invoked. Now, at a time when judiciary is fiercely fighting to protect its turf and independence, an internal model to guide judges' behavior can be a welcome step. The judiciary should rightly be fighting to safeguard its independence. Now, in this battle, a compromised judge weakens the moral authority of the entire judiciary, which is pivotal in protecting freedom and liberty. As the famous judge of America, Judge Learned Hand, who was in the bench for more than 50 years, starting very early on and going into the Kennedy regime. Well, Judge Learned Hand, amongst his numerous observations which have become legendary, well, he observed, and it's a wonderful quote from him, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. The spirit of liberty is a spirit which is not too sure that it is right. The spirit of liberty is a spirit which seeks to understand the minds of other men and women. The spirit of liberty is a spirit which weighs the interests alongside its own without bias. Truer today than ever before, and a crucial pearl of wisdom in the support of the concept of judicial integrity and accountability." This is your host editor, Inderjit Badhwar. Until next time, goodbye for now.
India Legal, stories that count.